Hello and welcome to another edition of ARM's podcast YouTube channel with me, Abbas Kazerounian. Today we have a one-on-one with our very own Jay Young. Not only is Jay a phenomenal arbitrator, mediator, and neutral generally, he's the author of several treatises, and he's also a Grammy winner. You can't say that about many people. The guy is genuinely a polymath. So welcome, Jay. Thanks for being here.
Thank you, Abbas. Appreciate it.
So I mean, like, we are going through some unprecedented times in our nation's history, both Nevada's history and the nation's history. Last 2 weeks, the numbers that have been coming out regarding COVID-19 have been the highest since the pandemic really began. And one of the reasons I really wanted to have a one-on-one with you, and you so graciously gave up your time for, is the fact that one of the major issues that are being faced by both landlords and tenants, both in the residential and the commercial market, is being directly hit by this pandemic. And so, having, you've done a lot of, commercial disputes before, and, like one-on-one disputes in the business context. I thought there'd be no better neutral kind of position to talk about this as far as, as it pertains to ADR, if you like.
Right.
But I think before we get to the ADR, it's important to lay some context down. So, I mean, when was the first time any directives or came down regarding evictions and things like that, do you think? Or do you know? I mean, I know you know, so I'm asking you.
Yeah, well, there are a couple of types. First of all, in Nevada, our governor came out with a directive back in March, the end of March, March 29th, that initially went a few months out, and it was a moratorium on evictions for commercial and residential evictions. That was extended for commercial evictions through the end of July, and then again extended for residential evictions through October 14. So those protections have been in place since the end of March. Then you have the CARES Act, which is a federal act, right. And it protects those who are either in federal housing or where the landlord in a residential setting is receiving federal aid, or it's a federally backed mortgage, and they're getting some relief. So Fannie Mae, Freddie Mac, VA, FHA loans, those sorts. The difficulty on the part of the tenant is it's difficult to know whether your landlord actually has that kind of a mortgage,
Right, of course. I mean, you probably won't know that from a tenant's perspective.
Right. And then finally, the CDC came out with its order back on September 4th, 2021. That extends right now, at least, through the end of the year, December 31, 2020. I can't see a scenario in which that isn't extended, given what you said at the top of the program regarding the spike in numbers.
Yeah, I mean, I would not be shocked, and I mean, this is conjecture from my end, but after the election, which is tomorrow, I would not be shocked if governors and on a federal level, these moratoriums or stay-at-home orders start to begin to change again. But who knows? I just hope that we stop spiking. It's just such a crazy time right now. But you just laid some really good context to how the moratoriums began in March and all of that. I want to kind of let's take it a step further. Like, during the moratorium, I think there's been misconceptions both by landlords and tenants as to their legal duties, because, and maybe you can extrapolate on that, because tenants may think that, for example, they don't owe the money that they didn't have to pay during the moratorium, and on the other side, the tenants, the landlords, I think sometimes misconstrued that because the tenants are not paying, their contractual obligations in other areas may have been alleviated, and that's not quite true, right?
No, it's not. The moratorium was for evictions for lack of payment of rent. if a tenant was in violation of the lease in other ways, they could be evicted and can still be evicted. And we can talk about the CDC order a little bit later, but the landlords, even though they're able to continue charging rent during that time period, and that rent obligation does not go away, late fees did go away for some time. There were no late fees in Nevada. There was a protection against late fees until September 1. And of course, that's gone away with. And under the CDC order, late fees are still applicable as well.
Right. I think the and like as far as the landlords go, like I mean, for example, on habitability issues, they still have their duty even though the tenants were not paying, correct?
Oh, absolutely. And some took an opportunity to try and let some of those things slide because, let's face it, not all landlords are these behemoth companies. A national group just did a survey and said that about 50% of landlords are actually mom and pop landlords. That's especially true in residential areas. So these are people just like you and me who are hurting as well. Their lives have been turned upside down, and suddenly the second home that they had as an investment is turning into a disaster because the government has come out and said that the tenant doesn't need to pay you rent. And then, of course, it's cascade, right? Then they have to run to their bank and try and get those protections. But in the meantime, they have every obligation that they would normally have to keep it habitable. And we're coming up into times when heat is going to be important, and AC here in Nevada during the summers. Those kinds of things. Water. It's all a requirement.
And one of the I mean, for those of you that don't know Jay very, very well, I mean, the guy is immaculate, like so detail oriented. And he sent me some materials before we did this podcast because that's the kind of guy he is. And one of the things that you sent to me that I found really fascinating is that some of these directives coming from the governor's office in Nevada apply to long-term motels, which I thought was very, very interesting. So they're treated like landlords essentially?
Right. So if you have like a budget suite, yes, they are. If those are long-term stays, and the moratorium applies to them as well.
Interesting. And so this kind of transitions us, like, we know the foundations and the rudimentary kind of foundation of where the directives are, as you very nicely and eloquently laid out for us. But this kind of now lends itself to the next topic of conversation, which is really why we're talking, which is ADR. And there was actually a directive from the governor on this, right?
Yeah, the governor's office was pretty proactive in saying, look, we know that this is disruptive to the marketplace. It's disruptive to the landlords. It's disruptive to the tenants. But remember, this obligation isn't going away. So they actually were proactive and put out an agreement that landlords and tenants could enter into that would extend that obligation. So it would say, we're not going to make you pay all that rent when the magic hour of, October 14th at midnight comes. You're not going to owe the entire amount the next day. If you've signed this agreement, we'll tack it on to the end of the lease, or whatever other arrangements could be made between the landlord and the tenant. The governor's office was out there preaching and saying, you need to call up your tenants, or you need to call up your landlord and get this worked out before we open the gates again.
Right. And I think, a lot of credit has to go to the governor's office because he foresaw the issue coming out on the back end of this, which, I mean, the first moratorium ended in October, a few weeks ago now. And so I think it's unrealistic to think that when people are losing their jobs, going through this massive pandemic, they're going to come out owing 5-6 months rent and then going to the landlord, well, now that we're out of the pandemic, I'm just going to hand you a check for 6 months. That's probably not going to happen, right? And so, like, this is where the ADR forum comes in trying to negotiate what that looks like and how that repayment program is going to come back. And, professionals like yourselves are going to come into the equation. But he also put into place a mandate for, where people are actually going in for eviction and trying to get, past rent back as far as ADR is concerned, right?
Well, there was on October 6th, the Supreme Court put out some new rules that allowed for mediation either asked for by the landlord or the tenant in any eviction matter. So the landlord, when they file the eviction, can say, I want to mediate this, or the landlord in filing their answer can say, I want to mediate this. There's an immediate 30-day stop that is placed on any eviction. So it would be to any tenant's benefit to ask for that, really, because it's it's not free. You still have the obligation, but let me step back there. You still owe the rent. The mediation is free. It's paid for by the court. You might as well take an opportunity to try and come to some resolution with your landlord.
Right, but I mean, you made an interesting comment. You said it's in the interest of the tenant to ask for this, but I actually would actually say that the same is true for the landlord, because the old adage of a bird in the hand is better than two in the bush, right? If you can negotiate something, it may be more economically viable to mediate and get something. You may not get 100 cents on the dollar back, but you may get some money back, which would alleviate your need to incur additional expenses and attorney's fees in trying to get a judgment, which may, at the end of the day, just be a piece of paper.
Of course. Yeah.
And so I think there's incentive on both sides of the V as far as that's concerned. But let's take it a step further even now. And I was trying to give credit to the governor, but that was the Supreme Court. So well corrected on that one. Thank you. But so you're absolutely right. And I think for the, mom and pop, where somebody's just a landlord on just one unit or, just a couple units. And for small cases, it absolutely makes a lot of sense to go and use the free system in the court system in Nevada. But let's take it up a notch. Let's just stay in the residential, right? If you're a big landlord and you have, let's say, 1,000 units or something, and clearly, if you own 1,000 units going through the pandemic, you're not going to have one eviction to do at the end of the pandemic. There's going to be lots. And it actually, from my perspective, and maybe you will disagree with me because I know you've represented a lot of institutional clients in your time, and I've been predominantly a plaintiff's lawyer. So, like, if I was pitching this to an institutional defendant, I'd be like, it would incentivize you to pay for private mediation and go and do a mediation day where you do maybe 10, 15 evictions or whatever is realistic, because you don't have to pay your lawyers to go back to court 15 times.
Right.
Even though you may be getting a free mediation over there, A, you get to choose the quality of the mediator, and B, there's cost savings and economies of scale to be had. Do you think I'm on the right path here, or have I got it wrong?
Oh, absolutely. I mean, if you have somebody with a couple hundred units and they've got 45 or 50 of their tenants that they're going to be evicting, or at least in the process of giving them notice, it makes sense to put out a notice to everybody. Look, we want to be good citizens here. We realize that you're hurting. We're hurting as well. We'd like to get together and work something out for all of us. And so we've hired this private mediator who's a neutral. And we're going to hold a day, and we can do it virtually. If you can make it virtually, great. If not, we'll do it in person. And let's try and work out something that benefits you and benefits us,
right.
so that you can pay your rent and stay where you are, and we can keep you as good tenants, because that's what we want as a good landlord.
Right. And I think something else that I find interesting is, again, all kudos to the court system and the Supreme Court. And I think that has its place, and I think people should utilize it 100%. No questions about that. But I'm talking about for situations like we just described. I think there is also another utility to having one person do, let's say, 10 or 15 or 20 of them, because they get a much better understanding of the corporation and what is palatable to them and what is not palatable in getting a deal done, right? And so, whereas if you go through the court system, notwithstanding the different attorney's fees on multiple days, keep coming back, they're going to get different mediators, and they're not going to have that same kind of familiarity with someone like yourself that knows their pressure points and their Achilles heel to work both for and against them in trying to resolve these cases, because they know the formula and the blueprint from the other deals they've got done. Does that make any sense?
It certainly does, and not only one particular mediator, but I've had mediations with claims adjusters on personal injury claims where they've had 2 or 3 of us going, mediators going at the same time, mediating several cases at the same time, where you're an institutional client and you understand what your business points are. You might be able to have 3 or 4 mediators out there, each of them working with different tenants at the same time. And boy, you can ramp up that scale, right?
Yeah, of course.
And take care of all of them in a short period of time.
Yeah. And then kind of like switching gears lastly into the commercial sector. I mean, we're talking much bigger leases at that point, right? We're talking much more sophisticated parties with probably a lot more at stake. And I mean, I'm not sure how long of the mediations you get in court, whether it's even available to, is it available to commercial landlord tenants?
I have to admit, I don't know.
Yeah, I mean, like, I don't know, but even through my experience using pro bono, like, things through the court system in different jurisdictions, usually you get 3-4 hours for free. And I've never seen one for a whole day, but even if you get one for a whole day, I feel like the commercial disputes require a little bit more finesse, a little bit more subject matter expertise, and you're dealing with sophisticated lawyers and very sophisticated parties that are more difficult to try and negotiate a settlement with. And again, that's where I would also kind of point to the private sector rather than the pro bono sector.
Yeah, and you also typically have parties that are more intimately familiar with each other. They've typically had a longer relationship, and they anticipate having a much longer relationship. Some of these leases are 2 5-year time periods and 3 options for 5 years at the end.
Sure.
That's a long time period to be dealing with somebody, and absolutely. I think it's appropriate to be thinking about that. I have friends who are in landlord-tenant law, and they are living at the courthouse right now because they have so many of these cases. And I would reach out to them and suggest to them, let's schedule a couple of days, and you can avoid all those trips to the courthouse.
Yeah, because you've got, it must be interesting to be in the landlord-tenant market as a lawyer right now, because your business must be booming, but with clients that can't pay. but on a serious note, I think that if there is one takeaway from our chat today, it's the fact that I think there's actually economies of scale and economic efficiencies in going through the private sector, which is counterintuitive to what you see on the surface, that the pro bono panel is for free. And I think, and I re-stress that, I genuinely believe for small actors in that market, that's a perfect forum. But for the bigger fish in that particular ocean, I think the private sector may work better.
Yeah, and it's going to be a while before they have that all figured out. They're just getting their mediators in place, and they don't really have a system for it. Right. I mean, this is was created 3 weeks ago, so it's going to take some time.
3 weeks ago.
Yeah.
Wow. And just an additional plug for ARM is that we're actually kind of suited to not only do we have the infrastructure for the remote mediation, so you can be doing numerous virtual mediations if it were a time where it would be safe to do in-person mediations. And right now we are doing hybrid or in-person if the protocols are followed. We have close to 30 conference rooms that would allow for that, which not a lot of ADR facilities have that kind of space and ability to do that. And it's not and the one thing I'm really proud of at ARM is that we didn't convert an office building to suit an ADR purposes. This was built out as an ADR facility from a shell, which distinguishes us a little bit.
Yeah, it's clear that it was made for that purpose, and it's a beautiful facility. And I would invite any local attorney who hasn't been there, come join me for lunch, and we'll go take a tour, and you'll see what they have to offer.
Absolutely. That offer is always welcome. We would love to show off our facility to anybody who wants to look. So with that said, do you have any parting words, Jay? You're honestly amazing.
I wish you well, and I wish the viewers well. I can say that for those that are lesser income, that Legal Aid of Southern Nevada has some fabulous resources. Go to their website, lasn.org, I believe. But Legal Aid of Southern Nevada, if you can Google them, they have some great resources. They're wonderful people over there. We work closely hand in hand with them as well on a number of projects. So big fan.
And our producer Zach is going to make sure that website that you just said is spelled right with the right link at the bottom when before we post it on our website. And so from my perspective, first of all, I want to thank you, Jay, for giving up your time and doing the research that you did into this topic. You really are a amazing individual. Thank you for all your insight. And to the viewers and listeners, please stay safe, please stay well, and we hope that we can be seeing you in person, not just virtually, in the very near future. So with that, thank you and see you soon.
Amen.